Hello, welcome to Life Matters. I'm your host, Brendan O'Connell. Well, as we start the show today, we want to mention that we have a sponsor for our show. It's Choose Life License Plates, and they have a website, chooselifemassachusetts.org, so check it out when you get a chance. Well, we're delighted to have in studio a fellow Bostonian, no less, who went to Catholic Memorial High School and then matriculated at St. Michael's College and I believe the University of Florida Law School. And he's involved with the Pro-Life Legal Defense Fund here in Massachusetts. So we want to find out what it's all about, the Pro-Life Legal Defense Fund, what they do, and why they exist. So welcome, Attorney Bob Joyce.
Thank you, Brendan. It's very nice to be here today.
I hope your commute was okay in getting here, Bob. Now, how did you get involved in the Pro-Life Legal Defense Fund organization?
Well, it was about 30 years ago. I got an inquiry about a case of the death of a stillborn infant, fully gestated, 9-month stillborn infant in the state of California. And I did some research on the law, and I found that the unanimous California Supreme Court had said that a wrongful death action would not apply, partially on grounds that interaction and communication between the mother and the unborn child did not begin until the moment of birth. Now, that didn't seem like a rational conclusion to me, and I decided to look into the case and to enter the case and to handle the case. And we had a successful outcome on that. And then about 7 or 8 years later, I saw that Henry Hyde, the former congressman from Illinois and a great pro-life stalwart leader, was giving a lecture in Boston as part of the Massachusetts Citizens for Life Assembly for Life. And I just went in to watch him, and I thought he gave a very persuasive speech, and he looked like he needed some younger legs, and my legs were younger then, so I decided that I should probably get involved in that. And I ended up joining MCFL and being recruited to the Pro-Life Legal Defense Fund, and I've been active for the past 20 years.
I see. Can I ask you about the case in California? Do you have a law degree or a license to practice in California?
No, but what you can do if you're practicing in a jurisdiction where you're not licensed, you can appear with a lawyer who is licensed in that state. It's called pro hac, Latin pro hac vice, and I was able to conduct the case on a pro hac vice basis with a California lawyer who had entered an appearance on the case as well.
I see. Now, what is the Pro-Life Legal Defense Fund here in Massachusetts, and what are some of their activities?
Okay, the Pro-Life Legal Defense Fund originated a little over 40 years ago in response to the Roe v. Wade decision. And it was felt that there was a need for lawyers to dedicate their efforts to advancing the pro-life cause because of the many legal challenges which were evident at the time. So a group of lawyers got together and formed a group and then incorporated in 40 years ago. And we've been active ever since. We litigate cases at the trial level in the state and the federal courts here. We filed briefs at the appellate level in Massachusetts, at the Supreme Judicial Court in Massachusetts, and even at the appellate level, federal court, First Circuit Court of Appeals, and the United States Supreme Court. In addition to that, we're active with agencies and giving speeches to groups and being involved in general pro-life education. We formed a website, which is, I'd invite everybody to look at that because I think it's very good. Content rich, as you like to say, and that's at PLLDF.org. And you can see that there are 2 newsletters that we've published during the last 2 years that are very informative. So we have a website. As I say, we have a website. We have Facebook presence, and we just go about doing our job day to day, all on a volunteer basis.
Wow, I see. Well, what do you mean by an agency? I didn't know that you deal with agencies. What would be an agency?
Well, agencies exist in the executive branch of government, and for an example, the Department of Public Health is an agency where we have some activity now, and that relates to issues concerning what we consider to be grossly inadequate informed consent forms for abortion here in Massachusetts.
Now, what does the pro-life, your organization, the Pro-Life Legal Defense Fund, did that get involved at all with the big McCullen versus Coakley a lawsuit that occurred last year during the election year.
Oh, yeah, that's a great story. Yeah, we were involved from the very beginning of that. Over the course of 6 years here at the state level, that case, we lost at that case at the trial level 2 times and at the First Circuit Court of Appeal level 2 times before it was appealed to the United States Supreme Court, following which, as you know, there was a unanimous decision in favor of the pro-life cause. Yeah, a past president of the Pro-Life Legal Defense Fund, Phil Moran, was a counsel of record in that case, and a former member of the board of directors argued the case before the Supreme Court. That's Mark Rienzi. He left the organization when he took a position down in Washington, D.C. as a law professor at the Columbus School of Law at the Catholic University. But we were involved from the very beginning, right through the very end.
Till the very end. I remember that you made a trip down there, I think, the day the case was heard.
Yes, we went and also took 2 law students from the Boston College Law School. Over the past 2 years, there's been a pro-life society resurrected at Boston College Law School. It's called Lex Vitae, and under the leadership of a then second-year law student, Hanford Chu, and the cooperation of the present president of the Lex Vitae Society, law student Larissa Warren, and others, they've become quite active on the campus, and we've worked hand in hand with them. And 2 of the students went down and listened to the arguments in McCullen versus Cullen, and it was a great opportunity for them.
Mm-hmm. I heard that Martha Coakley didn't try the case. She sat in the last row of the back seats of the courthouse.
Right, she assigned that difficult task to somebody else.
Now, I just wanted to ask you, law students get involved. How are law students getting involved? I mean, your organization reaches out to law students. What kinds of things do the law students do for the pro-life cause?
Well, really a number of ways they have helped. They assist directly in the drafting of briefs that are submitted to appellate courts. For instance, in the Hobby Lobby case, which was decided last year.
And that had to do with abortifacients?
Yes, that was the Supreme Court case that basically opened the door for Christian leaders of closely held businesses whose religious beliefs prevented them from participating in providing abortifacient contraceptives to their employees. That case opened the opportunity, protected those businesses from the mandates of the so-called Affordable Care Act. And members of the Lex Vitae Society and members of the United States of the Massachusetts School of Law participated in writing and what's called an Amicus Friend of the Court brief, which was submitted in that case, and interestingly, was cited 2 times in the case. So if anyone thinks that amicus briefs don't count, they do, and the Hobby Lobby case was evidence of it. And that's a great experience for the law students to have. That's a real feather in their cap.
Yeah,
and I would say to our audience here, Brendan, that if there are any law students that are listening, or parents or family members of law students who like this cause and would like for their friends or their siblings to have what I think would be a very fruitful and pleasant experience with this pro-life cause, they're very welcome to contact us at the PLLDF.org website. We have wonderful projects that they can get involved in.
In fact, wasn't Mark Rienzi a student and he kind of joined your organization as a student, or came to your dinners, and then he rose up, and now he's in front of the Supreme Court.
Yeah, Mark was very involved as a law student with Professor Dwight Duncan, who now teaches at the Massachusetts School of Law, and with Professor Mary Ann Glendon, who is and was a teacher over at Harvard Law School. And he cut his teeth, so to speak, as a law student. And when he graduated and passed the bar, he became a member of our board of directors, and as I mentioned, served until he transferred to Washington, D.C.
I see. Now, you also deal with not only beginning of life issues, but end of life issues. And you had a case at Mass General Hospital, which is here in Boston, the Barry Tevro case. Could you tell us a little bit about that and why that's important?
Well, that was actually the second time that we had been involved in obtaining injunctive relief from the Massachusetts courts, stopping the Massachusetts General Hospital from denying resuscitation to a patient who wanted it. In this case, this gentleman, who was 66 years old and a high school football coach of 20 years, a real fighter and a wonderful guy. Mm-hmm. He was transferred over to the Mass General Hospital. He was in a condition where he had cognition. He knew what he was doing. He was able to verbalize whisper responses. And he had a healthcare proxy who was his wife of 39 years, and they had 8 children, all of whom were behind his life and wanted him to continue to live. Mm-hmm. During his course at the Mass General Hospital, a doctor wrote in the record that he didn't want life-sustaining treatment, and he didn't want to be resuscitated. And his wife said, "No, that isn't what he's saying. That's not what he's saying at all." And so she demanded and received an immediate psychiatric consult, and the psychiatrist from Mass General said, "No, that's not what he's saying. He wants treatment." And so they got past that hurdle. Later on during the hospitalization, a senior medical resident determined that he was competent and did not want, that he was clear of mind and did not want life-sustaining treatment. And his wife said, "Well, no, that's not true. He isn't lucid right now." And the psychiatrist was brought in and confirmed her impression. And no, he's not lucid. So there were these efforts to kind of put decisions into the mind of the patient. In any event, we went into court and obtained a restraining order prohibiting them from failing to provide resuscitation. Interestingly, during the case...
Go ahead. What about hydration? That's so important.
That didn't come up in this case. Mm-hmm. That didn't come up. In the course of handling that case, we came upon a study that was very, very shocking and very upsetting. It was a paper that was presented at the American Thoracic Society International Conference, and it dealt with the what they call the unilateral imposition of do not resuscitate orders by Mass General. And they've had this program since 2006. And they have this committee that they call, and it sounds Orwellian to me, they call it the Optimum Care Committee. And in these cases, the optimum care for the patient is a denial of resuscitation, even if the patient wants it. And shockingly, over the course, it's been in existence since 2006. Most people don't know this. We didn't. But there have been 147 cases reported of conflict between the patient and the Optimum Care Committee. And shockingly, of those, 41% of them were cases which did not involve end-stage conditions. In other words, they were reversible conditions, but nevertheless, the Mass General Hospital Optimum Care Committee decided that, notwithstanding the patient's intent, they weren't going to be resuscitated.
Wow, that's really something. Well, with the onset of rationing and Obamacare, is that going to be accelerated then? This, for instance, a group like that Optimum Care Committee, would they be seeing more cases coming in front of them? Well,
I don't have a crystal ball, but I think that would certainly be a reasonable inference, Brendan. And interestingly, during that case, we asked whether or not the Mass General Hospital had been informed by any medical insurer or medical payor. Had they been informed that either the payments would be suspended or that there was a threat of suspension, because we wondered whether or not finances were part of the mix that caused the Optimum Care Committee to come up with this decision. We weren't able to get those. We weren't able to get those records. This patient passed from this life on his own terms in his own time before the case was finally resolved. But he was protected from the infringements upon his rights and the patient Bill of Rights until the time of his demise.
I see. Now, Frank McNamara, who's an attorney we both know, he penned an article entitled, "For the Unborn Child Under Massachusetts Law, Strangers are Dangerous, but Mothers Can Be Absolutely Fatal." What is the gist of that? It's quite a headline. And what's the gist of that article? And what was... Frank, who was a member of the Pro-Life Legal Defense Fund.
Yeah, Frank is a former U.S. attorney here in Massachusetts and a brilliant lawyer and a wonderful guy. And the gist of that article was that, as he said, there is a schizophrenic state of law here in Massachusetts. When you deal with wrongful death civil statutes and/or criminal homicide statutes, an unborn child, also known as a fetus, which is viable, that means capable of living outside of the womb, it can be a moving party or can receive damages for wrongful death if a third party, through negligence or intentional act, ends the life, and that would be in a civil context. The person can also be responsible in a criminal context under the homicide statutes. However, that same person is not safe from his own mother, and he said that's a kind of a schizophrenic type of approach.
Is there anything that you could do, or is that a legislative approach, a legislative thing that they would have to change the law so that it would?
I think most.
Other than get rid of Roe versus Wade.
Well, I think most likely the legislature would be the surest avenue on that. It's interesting though, Brendan. Lawyers deal in facts, and facts are very important in the law, and they're important to uphold and or interpret existing laws. They're important if people think that existing laws should be amended or repealed, and they're important if people feel that there's a need for new laws. Now, facts are sometimes easy to overlook. We live here in Massachusetts, and just south of where we are, we're in Boston, and just south of here, down in Quincy, was the home of John Adams, the second president of the United States. And John Adams had a very interesting thing to say about facts. John Adams said that facts are stubborn things. And no matter what our wishes are, no matter what our inclinations are, or no matter what the dictates of our passions are, they don't change the state of the facts and the evidence. And Adams went on to say that for his part, whatever anguish of mind may be the cost, he was willing to know the whole truth, the worst of it, and to provide for it. And in this area, in this pro-life area now, I think we're seeing the demonstration of facts which are shocking to the public, and I'm referring to the videos of the Planned Parenthood and STEM Express, which have recently been released by the Center for Medical Progress. And these are illustrating the humanity of the unborn child, because they're seeing that these are not just blobs of tissue, and these are not, as the Massachusetts informed consent statutes refer to them, they're not simply the contents of the womb. They're members of the human family.
Well, wasn't there a swimmer that was the contents? We were all swimmers in the womb at one time.
Well, that's a very good point. The informed consent laws, the informed consent forms that are in use in Massachusetts are being challenged by the American University Women for Life. That's a group of women from a diverse background who have looked at the consent forms and said, no, these aren't right. These don't tell enough of the story, because the statutory definition of abortion in Massachusetts is the destruction of the life of an unborn child, okay? But the forms, which are supposed to provide meaningful information about the procedure, they just refer to abortion as emptying the contents of the womb. And some people think that that's kind of like describing Michael Phelps as a guy who learned to swim one time, or describing an Apollo spacecraft as a vehicle which can move. You know, while both of the statements are true, they completely fail to reveal the full reality of what's going on. And so we think that as people come to understand more about about the embryo and about the developing life and about what is really involved in it, that their eyes will be opened to the reality that these are members of the human family.
Well, these videos have brought about nationwide protests. because they show not only are they aborting the child, but they're selling the parts of the child to STEM Express and some of these other medical research labs.
Yeah, there's some debate about whether it's being sold or whether it's being donated, and then whether or not it's justified or it's not justified. But the essence, the reality is that we're dealing with real life. One person, a noted professor, has opined that when we're dealing with this abortion question, we have to ask one fundamental question, or face one fundamental fact. He said that every induced abortion necessarily involves the killing of the life of the human being that is being aborted. And embryology, science, you don't need religion to believe that, okay? Because religion certainly can justify that belief, but a very noted atheist, Nat Hentoff, a famous civil libertarian, renowned author, who is an atheist, states that his belief in the pro-life movement is not rooted in the Bible, but in texts of embryology. He just doesn't see a significant difference between the life within the womb and the life afterwards.
I see. Well, now, can you speak of the various, the expansion of the notion of personhood with respect to the viable unborn? I guess you've just spoken of that.
Yeah, I think we've kind of mentioned that. Yeah.
And what about these, a long time ago I've done a show on the Mary Moe petitions. Could you explain what are Mary Moe petitions and why we have them in the state of Massachusetts? And are they, are there dangers to the Mary Moe petition?
Sure. Mary Moe petitions are petitions by which a minor, a woman who's minor, has not reached majority, can obtain an abortion without the consent or the knowledge of the parent. It's sometimes referred colloquially as a judicial bypass. And in these cases, the minor goes into court, usually with a lawyer who is paid by taxpayer dollars, and the court reviews conducts a preliminary inquiry to determine, first of all, whether or not the minor is mature. If the court determines that the minor is mature, then that's the end of the story. She can have the abortion without any parental consent. If the minor is not found mature, then the judge makes an inquiry as to whether or not the abortion is in the best interest of the minor. Now, Pro-Life Legal Defense Fund found out some time ago that reviewing the history for a period of 20 years, judicial bypasses were granted in 99.9% of the cases that were presented to the Superior Court during that period of time. It was essentially a rubber stamp. Mm-hmm. And we assembled a group of retired judges, of lawyers, of doctors, of lay people to make recommendations to improve the guidelines. Now, why do I say the guidelines? The guidelines were established in 1981, and they guide the way a Superior Court judge is instructed or persuaded to approach these. And those guidelines steer the inquiry, specifically, they steer the inquiry away from an inquiry into whether or not the minor child views the abortion as the destruction of life, or whether or not the minor feels that she is in some sense dealing with an unborn child, and specifically deals away from the child's and or the parent's concept of morality. Now, Pro-Life Legal Defense Fund said, well, those are the bedrocks of mature and informed decisions, and they shouldn't be off limits in Massachusetts. And we've presented that to two different on two different occasions. We've been unsuccessful both times, but we have a new Superior Court Chief Judge, so we're gonna present it again.
Very interesting. Well, Bob, our time has come to an end, unfortunately.
Really?
I'm sure we could talk quite a bit more about many different subjects, and thank you for coming in.
Well, could I just mention that Pro-Life Legal Defense Fund is a tax-exempt 501c3 organization, and if anyone likes our work and they want to make a tax-deductible donation, we'd love to receive it.
I see. Okay. Very good. Well, and any of you students out there, law students or practicing attorneys that have a desire to be involved and do the good thing in our society, then contact Bob at the Pro-Life Legal Defense Fund, and I'm sure he'll be able to steer you the right way. Well, we hope you enjoyed the show, and we hope that you found it to be unique, informative, content-rich, truthful, and thought-provoking. Thanks for watching. I'm Brendan O'Connell, your friend for life.